taxes going to the schools, regardless of whether it was paid late or resulted from an underpayment. No matter what, it was still royalty money, and there's only one reasonable interest rate that can compensate them for that. But even if the second requirement is satisfied, that it was a reasonable forecast of just compensation, you still have the third independent requirement, and that's that actual damages cannot significantly differ from the damages awarded in this case. And here, the board's actual damages at the time of judgment were $6 million. But the trial court awarded $30 million in prejudgment interest. That ratio, 6 million to 30 million, has already been held to be unenforceable by the Texas Supreme Court. And the Texas Supreme Court talked about that in its 2020 Atrium decision, and it's discussed at length its own decision in FPL Energy. In FPL Energy, the ratio was exactly the same, 6 million approximation of actual damages versus 29 million in FPL Energy awarded, and the court held that that was an unenforceable ratio.
So the board says that it's your burden to show what actual damages would have been. Do you agree with that?
Yes, it's our burden, the board's burden on the third requirement. I'm sorry, it's IDEX's requirement on the burden on the third requirement, and the board's on the second.
So what is the evidence that you have of actual damages?
The evidence of actual damages was submitted by an expert at the time of judgment, and the expert calculated the board's damages using the prime rate to come to the 6 million. That was an approximation of their damages, and an approximation suffices under the Atrium case. And that was the best approximation possible because the prime rate is not just one rate, the prime rate fluctuates with the market. So that's what that approximation was appropriate.
So how would IDEX calculate what is owed?
If this court were to hold that the interest rate was unenforceable,
yes,
then in that case, you couldn't enforce the 18% interest, but you would still have to decide on an interest rate. So you would go back to the contract interpretation issue. So if the contract provided for the prime rate, then the interest rate would be the prime rate. But we're assuming that you've already decided that the interest rate is not the prime rate because you're reaching unenforceability. So in that case, prejudgment interest is awarded in equity. So it could be no interest, or it could follow the post-judgment interest, which right now that rate is 7.5%. The brief said 8.5% right now. The post-judgment interest rate is at 7.5%. So that's prejudgment interest. It could be 7.5%, 0 it's awarded, or something else it's awarded in equity. And then the post-judgment interest would be provided for by statute, which is 7.5% right now.
So both this court and the first court have enforced 18% prejudgment interest rates, right? In the Eichner and Said cases. How do you distinguish those cases?
Those cases only involved one interest rate. So here, a key difference is that this involves two interest rates. And the board cites no case and no authority that involves two interest rates. So this is a very fact-specific case when it comes to penalty, and that this contract is very unique in that it awards two interest rates for the same exact lost use of royalty money. And if the court has no further questions regards to penalty, I'd like to turn back to section 5.3 and the problems with the board's interpretation with 5.3. So the first problem with the board's interpretation of 5.3 is that it says that the board is misreading 5.3. The cost of the examination and interest are right next to each other, and so the natural reading there is that IDEX must pay the cost of the examination, that being the principal, and then that interest accrues on that principle.
So the board says that you didn't preserve that issue. What's your response to that?
We did. We preserved that argument in both in an amended response to the board's motion for summary judgment on damages, and also in a response to the board's motion for final judgment, and we appealed the final judgment. But I also want to point out the important distinction between an argument and an issue. In other places, we raised the issue that 18% is not the correct rate under the contract. This issue about the cost of the examination is an argument that supports that issue, which can be raised at any time, which can be raised even anew on appeal, even if it wasn't raised before, although we did raise it below. Thank you.
Thank you, Counsel. May it please the court. IDEX is trying to avoid the contractual interest it agreed to pay on royalties the Supreme Court has found that IDEX owes the board. IDEX used the board's patents to net almost $1 billion on product sales, out of which the Supreme Court held IDEX must pay an additional $18 million in royalties under the contract's terms. Those terms also say that if IDEX is discovered to have materially underpaid the royalties it owes, as it did here by some 400%, that deficiency will bear interest at the highest rate allowed by law, that is, the rate set by the legislature. IDEX's efforts to avoid this unambiguous interest provision uses the same interpretive playbook it used in the Supreme Court as to royalties, including failing to reconcile key contract provisions. IDEX's arguments are just as flawed when applied to Section 5.3's interest provisions, and the court should reject them. The trial court properly awarded 18% interest on underpaid royalties. Section 5.3 expressly covers accrued interest and costs that are owed when a board examination reveals that royalties have been, quote, underpaid, close quote. Section 5.6, on the other hand, plainly covers interest for late payments, defined as those that are made beyond their quarterly due dates. It may be rhetorically true that both sections 5.3 and 5.6, if considered in isolation, could apply to the interest on unpaid royalties, but the Supreme Court has already said exactly how this situation should be resolved. It held in the prior appeal where two contractual provisions might apply on their face, courts must, and I quote, read the contractual provisions together, not separately, giving meaning to all and considering them in the context of the licensing agreement itself. This court had found in the prior appeal that two royalty provisions in the parties' licensing agreement, one for 1% and one for 2.5%, considered separately in the abstract, could logically be read to apply to the same sale of goods. But the Supreme Court decided that the provisions must be read together and in context to give them meaning.
So how do you construe the all royalty payments which are not paid under Section 5.6?
First, we have to look at 5.6 and 5.3 and see what each of those are doing, and I'll come back to that in just a moment. But all isn't rendered meaningless. The word all in Section 5.6 refers to royalty payments which are not paid by the 31st day after each quarterly payment date. That applies to all late payments relating to quarterly payment due dates. So applying Section 5.6 to all payments not made within a certain time of the quarterly payment date still gives effect to the word all as used in that section, even if it excludes underpayments discovered after a board examination, which is what Section 5.3 specifically addresses. And let me turn now to Section 5.3 and look at that in conjunction with Section 5.6. Sections 5.3 and 5.6 deal with different things. Section 5.6 deals with payment terms, where the payment must be made. It must be made in US dollars. It must be made within 30 days of the payment due date, etc. Whereas Section 5.3 deals specifically with underpaid royalties determined to be owed through a board examination of IDEX's records, and it awards both cost and interest in that specific scenario.
So what if the board audit revealed underpayments by less than 5%?
Then there would not be interest owed under Section 5.3. The 5% is a materiality provision. And
So would it be owed under 5.6 or no interest owed at all?
It would be no interest. The royalty would still be due under section 5.4, but there would not be interest. There's a materiality provision that requires it to be at least 5%. And that's exactly the way 5.3 works. 5.3 is a very simple provision. It allows the board to go in and do an audit for up to 2 years after the contract is over. If a royalty underpayment is determined, and that's at least 5%, then IDEX has to pay cost and interest. Very simple. They pay the cost of the examination, they pay interest on the underpaid royalties. That is exactly what section 5.3 does. That is the purpose of that provision, as opposed to section 5.6, which simply deals with late payments.
What is your response to IDEX's argument that this case is factually different because it has 2 different interest rates?
The court has to read this contract and read the contract together and read these terms to see what it means. They have cited no authority that says parties can't agree to have two interest rates in Texas. Parties have the right to agree as they choose, and here there are 2 interest rates doing different things. This goes back to what the Supreme Court said in the prior opinion here. The court there said that the parties must have intended that the provisions, in that case for very different royalties, would apply in different and mutually exclusive situations. The exact same reasoning applies here. All that you do is replace the word royalties with interest rates. The parties must have intended that the provisions for different interest rates would apply in different situations, and that's exactly what we have here. A very simple agreement. The first interest provision is 5.3. If they're underpaid royalties by 5% or more, then IDEX must pay cost and interest on the underpaid royalties at the highest rate allowed by law. Then you have section 5.6, which deals with when payments aren't made timely. In other words, they send the report, they don't attach the check to it.
So if we have these 2 different interest provisions that apply to 2 different situations, how are those a reasonable forecast of just compensation?
I believe they're both a reasonable forecast. IDEX here basically concedes that both of these could be at 18%. If they were both at 18%, there wouldn't be a problem. The problem, they say, is because there is a lower rate also in this contract, therefore that must be the reasonable forecast.
Is 18% a penalty?
It's not, Your Honor. It's the highest rate allowed by the legislature, and 18% is routinely upheld by the Supreme Court, by this court, by other courts. 18% is the amount that the legislature has said that Texas law allows. And
in the cases that we've upheld 18%, did anybody argue that was a penalty?
no court has ever held in Texas that we found that IDEX has cited. No court has ever held that a 18% interest rate is a penalty. No court has even hinted at that. 18% has always been upheld. I haven't seen it challenged as being a penalty, but no court has held that.
Right. Yeah. I was asking more if anybody's made that argument.
Right. And it's because the legislature has said that's the reasonable rate. As a matter of law, 18% interest can't be a penalty. The legislature has said that's the legal rate in Texas. So as a matter of law, it can't be a penalty.
I mean, in any situation, like 18% could be a penalty in some situations, surely.
There might be a situation that I can't think of what the hypothetical would be right now, Your Honor, but there could be. Certainly it isn't here. This is contractual prejudgment interest for the highest rate allowed by Texas law. That must be in tens of thousands of Texas contracts. I mean, that is fairly standard contract language. And to say this now is a penalty because a party put another interest rate in would simply revolutionize the way courts have to deal with prejudgment interest. And that simply can't be right. No court has ever held that. No court that we have found has ever held that prejudgment interest can constitute liquidated damages. So because there are no liquidated damages, that's the first step in the analysis. It's not a liquidated damage and therefore can't be a penalty. It's not otherwise a penalty because the legislature has set this as the legal rate. And again, there's no authority that deems any rate at or below the lawful maximum as an illegal penalty.
So why couldn't prejudgment interest be a liquidated damages clause? This atrium definition, a measure of damages the parties stipulate in advance, that seems like it could include prejudgment interest.
I think for a couple of reasons, Your Honor. The second, if you go to the second prong, in that it has to be an amount of liquidated damages being a reasonable forecast.
Well, I'm just talking about whether it's a liquidated damages clause in the first place, not whether it's enforceable.
Got it. I don't believe it fits the definition, because the Supreme Court has said the definition is where the parties fix in advance the compensation to a party. And I know there are cases saying that prejudgment interest is part of the damages a party recovers, but what that really is interest on the underlying damages to make the party whole. No court has specifically addressed it, but I don't think it even fits the definition of the first element, to answer that question, Your Honor. I don't believe it would fit that, but even if it did fit that, it wouldn't fit the second element, because as a matter of law, it is a reasonable estimation, because the legislature has said that it is.
So you're saying it's not prejudgment interest, it's damages?
No, Your Honor.
The interest is the damages.
This is contractual prejudgment interest. I think for the purpose of defining what is liquidated damages, I don't believe prejudgment interest is liquidated damages. I don't think it fits within the definition. I haven't had a case, I don't find a case that says exactly that, but looking at the definition, looking at the purpose, and also because of the fact no court has ever held that prejudgment interest is a liquidated damage. If prejudgment interest were liquidated damages, we're now going to have many trials on prejudgment interest. The first thing is you basically can't have a fixed rate anymore, especially in a long-term agreement. And here we've got an agreement spanning some 20 years. You wouldn't be able to have a fixed rate because the interest rate is going to fluctuate. And if whatever interest rate you pick, if the interest rate goes down, well, now you might have an unbridgeable discrepancy. And so you're going to be litigating every time you have prejudgment interest and having many trials on it. Plus, like in this case, even if they allege there is a discrepancy, IDEX had the burden to come in and show that. What IDEX argues, there's no evidence in the record of that. There is no evidence of what the board would have earned on this money. What IDEX argues as a substitute for that is the prime rate. That's not what the prime rate is. The prime rate is what a bank charges its best customer on a short-term loan. That has nothing to do with what the board could have earned on this money over the last 20 years. It is simply no evidence of that.
But you accepted the prime rate in some circumstances.
I'm sorry, Your Honor.
You accepted the board accepted the prime rate under 5.6. So the prime rate is appropriate in some circumstances.
We did, but that's not saying that's what we could have made in the market. That was the contractual rate the parties agreed to, and it makes sense there because again, that is probably going to be a short-term rate. Because what happens is when 5.6 is triggered, it's the situation where IDEX sends the report for the royalties, but they don't attach the check. They don't pay that within 30 days of the end of the quarter. And so that's probably going to be a short-term situation because if IDEX continued that, the board would find them in breach and the agreement would be brought to litigation or something else would happen. So it makes sense for the parties to use a short-term rate like that in 5.6. 5.3 on the other hand, the interest here goes back to 2004. This is a long-term agreement. The parties put a materiality provision in, which makes perfect sense here from a business standpoint. And they also set interest at the highest rate allowed by Texas law. That also makes sense in that situation because you have interest rate risk over that window whenever you have a fixed rate. The parties are having to project what interest would do over a 20-year window. So it makes perfect sense to use a different rate there. It's just like the Supreme Court said, when you've got two different provisions, you have to assume that the parties intended that the provisions would apply in different and mutually exclusive situations. That is exactly what we have here. We have a situation where there's a late payment in 5.6, the parties set an interest rate for that, and you have a situation where there's a potentially long-term interest and the parties set an interest rate for that. They are both lawful rates under the maximum legal rate in Texas set by the legislature.
If the board is correct that 5.3 applies, then how would you determine an accrual date?
The accrual date is set under 5.4. It's whenever the money is due, and 5.4 sets the due date. IDEX argues that the board argued 5.6 to the trial court, and that's not the case. Section 5.4 is the provision that the board argued to the trial court in the motion for summary judgment, and that's pages 20, 90, and 91 in the record, volume 3, pages 20, 90, 91 of the clerk's record. So 5.4 is the due date, and whenever it becomes past due, that is when interest begins accruing. That was what was argued by IDEX. That was what the expert did in his calculations, If the court has no further questions, this court should affirm the trial court's judgment. Thank you.
Thank you, Councilman.
The parties agree that you have to harmonize section 5.3 and 5.6. You have to read the contract as a whole. But the board's position causes 5.3 and 5.6 to conflict. Section 5.6 applies to all royalty payments not paid by the due date. An underpayment results in a late payment not paid by the due date, just like no payment results in a late payment not paid by the due date. So for example, let's say IDEX owed $100 by January 1st, and it pays $0. The remaining $100 is not paid by the due date.
So it's ambiguous. Are you saying it's ambiguous?
No, our primary position is that it's unambiguously that subsection 5.6 applies interest to the royalties, and section 5.3 provides interest on the cost of the examination. That harmonizes them. It's simple, easy, and reasonable. But the board's, if our position isn't unambiguous, then I would say in the alternative there is ambiguity here, which would cause which would warrant a remand. So back to the example though, if you have an underpayment, if you have $100 due and you pay $1, then the remaining 99 that is paid is a royalty payment that is not paid by the due date. That falls squarely under section 5.6, which calls for the prime rate. The board's carve out for underpayments from 5.6 isn't for underpayment, or I'm sorry, for royalty payments that result after an underpayment just isn't there in the language of section 5.6.
Is the difference though between 5.3 and 5.6 that 5.6 it's just a late payment, but 5.3 is when the board has audited and found not that they just had there was a late payment, but that they did not pay a huge amount over time that was due. Is that not the difference between the two?
So section 5. That's the distinction that the board is trying to draw. But if you look at the language of section 5.6, it says all royalty payments that are not paid within 31 days after the due date. It doesn't say all royalty payments not paid by the due date, but only if there was no royalty payment at all. It doesn't have that carve out.
And so what would your response be to 5.3 is regarding underpayments?
5.3 specifically mentions underpayments, but only in the context of the condition that triggers the payment. So that's the only place royalties is mentioned in 5.3. So the first part of, and I see my time's up, but
go ahead.
I'll conclude. So the royalties in 5.3 refer to the condition that triggers the payment, and what must be paid is the cost of the examination and accrued interest on that cost of the examination.
Thank you.
Thank you.
Anything else? All right, thank you, counsel. Thanks to all of you for your excellent arguments. This case is submitted and we're adjourned. Good to see everybody.